Hello friends, the topic of today is what is charge sheet in the criminal case. My lesson plan includes why is it in the news, what is a charge sheet, how a charge sheet is prepared in a criminal case, can a charge sheet be quashed in the criminal proceedings, and finally conclusion. Now friends, you might be knowing that Honorable Supreme Court gave the verdict on Friday that a state is not obliged to provide the public free access to charge sheet by uploading them on police or government websites. A bench of Justice M.R. Shah and C.T. Ravi Kumar declared charge sheet private documents. Taking the clue from 2016 judgment of Supreme Court regarding FIR to be published within 24 hours of the registration on police or government website, it was contended that putting charge sheet in public domain will enhance public transparency. But the Supreme Court viewed that putting charge sheet in the public domain would violate the right of the accused, victims, and even the investigating agency. It would be contrary to the scheme of CRPC. The judgment of 2016 by Supreme Court regarding FIR to be published in the public domain was meant to protect the interest of the accused and to ensure that the innocent accused are not harassed and they are not taken by surprise. The court said that copy of the charge sheet along with necessary documents cannot be said a public document within the definition of public document as per section 74 of the Evidence Act. The court also held that copy of the charge sheet and relevant document do not fall within section 4(1)(b) of the RTI Act. What is a charge sheet? Friends, as you know that both in the criminal proceeding and in civil proceeding, a charge sheet is framed on which an accused can be prosecuted in the court of law or in the departmental proceedings. Today I am myself restricting to the charge sheet in a criminal proceedings. So a charge sheet refers to a formal police record showing the names of each person brought into the custody, the nature of accusations, and the identity of the accusers. It contains information about the accused and the witnesses, charges and a specification, summary of charges, and for the trial record. Once the charge sheet has been submitted to a court of law, trial against the accused starts. As soon as investigation is completed, officer in charge of the police station shall forward to a magistrate empowered to take cognizance of the offence on police report in the form of prescribed by the state government stating: number 1, the names of the parties; number 2, nature of the information; number 3, name of the person who are acquainted to the circumstances of the case; number 4, whether any offence appears to be committed and if so, by whom; number 5, whether the accused has been arrested; number 6, whether he has been released on a bond and if so, with or without sureties; number 7, whether he has been forwarded under custody under section 170 of the CRPC; number 8, the officer shall also communicate the action taken by him to the person by whom information regarding commission of offence was first given. The time limit to file the charge sheet is to be within 60 days to the date of arrest of accused in the cases tried by lower court and 90 days in cases triable by court of session. Supreme Court held that section 167 bracket 2 bracket A bracket 1 of the CRPC is applicable only in cases where the accused is charged with a offence punishable with death, life imprisonment, or offences punishable with minimum sentences of 10 years. In all cases where the minimum sentence is less than 10 years but the maximum sentence is not death or life imprisonment, then section 167 bracket 2 bracket A bracket 2 will apply and the accused will be entitled to grant a default bail after 60 days in case charge sheet is not filed. Friends, now I switch over to another point: how a charge sheet is prepared in a criminal case. Number 1, when a cognizable offence occurs in the jurisdiction of a police station, the officer in charge of the police station is bound to write FIR. FIR may be information given in writing or oral. A copy of FIR must be given free of cost to the informant. If his complaint is not registered in the police station, he can send complaint to SP of the district, who shall direct the investigation of the case. Anybody who is acquainted with the case can file first information report at the police station. After registration of crime, a copy is to be sent to the senior officer, while another copy is sent to investigating officer, while the third copy is kept as record at the police station. Investigating officer takes the statements of witnesses, informants, inspects the scene of crime, gathers physical evidences, if any, makes seizure memo and all relevant evidences necessary to prosecute the accused. Once the investigation is completed, a charge sheet is framed by investigating officer and then it is submitted to the jurisdictional court for trial. Friends, can a charge sheet in a criminal proceeding be quashed? Yes, the Supreme Court held that the criminal proceeding can be quashed when the complaint on the basis of which FIR was registered doesn't disclose any act of the accused or their participation in the commission of crime. The Supreme Court also issued the guidelines in case of Bhajanlal versus State of Haryana, and these are where the uncontroverted allegations made in the first information report or complaint and the evidence collected in the support of the same do not disclose commission of any offense and make out a case against the accused. Number 2, where the allegations made in FIR or complaint is so absurd and inherently improbable on the basis of which no prudent person ever reaches just conclusion that there is sufficient ground for proceeding against the accused. White Ramesh Chandra Gupta versus State of UP. So friends, Supreme Court has clearly given the guidelines on which a charge sheet or FIR can be quashed. Under 482 CRPC, High Court has the inherent power to quash an FIR or charge sheet against the accused if no cognizable offense is disclosed or there is no sufficient evidence against the accused. Conclusion. Friends, as you know that charge sheet is the sum total of investigation done by investigating officer. It contains evidences against the accusers, statements of informants and witnesses, relevant documents, medical examination reports. It is on the basis of charge sheet the magistrate frames the charges against the accused and then trial starts. During trial, examinations in chief, cross-examinations and re-examinations take place. On the basis of examinations of witnesses, accused and documents, the court arrives at the conclusion as to whether the accused are guilty of offense or not. And then court award sentence to the accused if found guilty. The accused can appeal against the judgment of the court in the High Court. And if death penalty is awarded to accused, that must be ascertained by Supreme Court. So friends, now I conclude my lecture. If you like my lecture, please share and subscribe and tell your friends that I am making regular videos on current topics. Please share and subscribe. Thank you.